What if a simple mistake on your citizenship application is now causing instant denials that could have been avoided? This is the alarming reality now facing thousands of naturalization applicants, as reports emerge that uscis has adopted a stricter approach to application errors that previously might have been overlooked or corrected during the interview process. The reason this story is spreading so quickly through immigration communities is because naturalization has always been viewed as the final step in a long immigration journey for most applicants. The process involves years of maintaining lawful permanent resident status, carefully documenting their history, and preparing for the civics and English tests. The expectation has always been that minor errors or omissions on the application could be addressed and corrected before a final decision is made. But what is now being reported suggests that uscis adjudicators are taking a much harder line on certain types of mistakes, and the consequences are immediate denial rather than a request for clarification. Sources familiar with current uscis operations indicate that the agency has issued internal guidance emphasizing strict adherence to application requirements and reducing the discretion officers previously exercised when encountering incomplete or inconsistent information. This shift appears to be part of a broader effort to ensure the integrity of the naturalization process and to hold applicants to a higher standard of accuracy and completeness. The most common mistake that is now reportedly triggering instant denials involves the failure to accurately disclose travel history outside the United States. The Naturalization Application Form N-400 requires applicants to list all trips taken outside the country during the statutory period, which is typically 5 years for most applicants, or 3 years for those applying based on marriage to a United States citizen. Many applicants struggle with this section because they may not have kept detailed records of their travel or may have taken numerous short trips over the years in the past. Officers might have worked with applicants during the interview to clarify travel dates or to account for minor discrepancies. However, reports now suggest that applicants who submit incomplete travel histories or whose stated travel does not match records held by CBP are facing immediate denial. The denial letters cite material misrepresentation or failure to establish eligibility, and applicants are being told they must refile and pay new fees to try again. Another common mistake that is reportedly causing problems involves the disclosure of employment history. The N-400 asks applicants to provide a complete employment history for the statutory period. Applicants who have had gaps in employment, who worked multiple jobs, or who were self-employed sometimes struggle to provide accurate dates and employer information. Sources indicate that uscis is now cross-referencing employment information with records from the Social Security Administration and the Internal Revenue Service. When discrepancies are found, applicants may be denied for failure to provide accurate information, even if the errors were unintentional. The failure to disclose all address history is another area where applicants are reportedly encountering problems. uscis requires applicants to list every address where they have lived during the statutory period. For applicants who have moved frequently or who have lived in informal housing arrangements, this requirement can be challenging. Reports suggest that officers are now more likely to deny applications when address histories are incomplete or when background checks reveal addresses that were not disclosed on the application. Perhaps the most serious category of mistakes involves the failure to disclose interactions with law enforcement. The N-400 asks detailed questions about whether the applicant has ever been cited, arrested, charged, or convicted of any crime. It also asks about traffic violations and other encounters with police. Many applicants make the mistake of not disclosing minor incidents that they believed were resolved or expunged under current enforcement guidance. Any failure to disclose such incidents, regardless of how minor, can be characterized as an attempt to conceal material information. This can result in denial and, in some cases, referral to ICE for potential removal proceedings based on alleged fraud. Immigration attorneys report that clients are being denied for incidents as minor as traffic tickets that occurred years ago, and that the applicants genuinely forgot about the standard being applied appears to be one of absolute accuracy, with little room for innocent mistakes or memory lapses. For applicants who are currently preparing naturalization applications or who have applications pending, this development requires immediate attention. Experts strongly recommend gathering complete documentation before filing, including detailed travel records from passport stamps and CBP entry records, complete employment history with dates and employer addresses, all addresses where you have lived, and records of any interactions with law enforcement, no matter how minor. Applicants should also consider requesting their own CBP travel history through the DHS website and reviewing their Social Security earnings record to ensure consistency with their application. For those who have already filed and are awaiting interviews, it may be wise to review your application carefully and to bring documentation to the interview that supports or clarifies the information you provided. If you discover errors in your pending application, consult with an immigration attorney about whether and how to correct them before your interview. At the institutional level, USCIS has not issued a formal public announcement describing a change in how application errors are handled. The agency continues to state that each application is reviewed on its own merits and that officers follow established policy and procedure. However, the pattern of reports from applicants and attorneys suggests a significant shift in how mistakes are being treated. For the millions of lawful permanent residents who hope to become United States citizens, this is a critical moment. The naturalization application is not a document to be filled out casually or quickly. Every question matters, and every answer must be accurate and complete. The consequences of mistakes that once might have been corrected are now potentially severe and immediate. This is a developing situation, and further guidance may emerge from USCIS or through litigation challenging some of these denials. For now, applicants should proceed with extreme care and should consider seeking professional assistance to ensure their applications are as accurate and complete as possible.